So welcome and good morning. I'm Trevor Morrison. I'm the Dean of the Law School here at NYU and delighted to welcome you all to today's symposium. The annual survey of American law each year welcomes academics and practitioners to the law school for a day of discussion devoted to an important and timely topic in a pressing area of the law. And this year, the symposium will explore the future of securities class actions, and this will include consideration of the relationship between securities class actions and the enforcement role of the SEC, the future of securities class actions after Halliburton II, and other important and timely topics. We're really benefited by a terrific array of speakers on each of the panels today, from leading academics to leading government officials, including former leaders of the SEC, the chief of the SEC Enforcement Division and a former SEC commissioner, as well as leaders in the bar, and that includes today's keynote speaker. We're really grateful that Carter Phillips, partner and chair of the executive committee at Sidley Austin, will do us the honor of delivering our keynote address later in the day. He'll be formally introduced later on, but let me just say on behalf of the law school how grateful we are that Carter will be joining us, and indeed that all of today's speakers have made time to address these topics as part of our symposium. I also want to thank Michael Roberts, NYU class of 2016, and the Annual Survey Symposium editor, and Christina Liu, the Annual Survey's editor-in-chief, for the terrific work that both of them have done in making this event possible. This is a big week for the annual survey. Just a couple of days ago was the annual dedication ceremony where the upcoming volume was dedicated to Judge Weinstein, and we had a terrific event then featuring Christina, and it's good to be able to introduce her again this morning. So without further ado, Christina Liu.
Hi everyone, and good morning. Welcome to the New York Anniversary Annual Survey of American Law's 2015 Symposium, The Future of Securities Class Actions After Halliburton II. I'm Christina Liu, the editor-in-chief of the journal. And on behalf of the journal, thank you to all of our distinguished scholars and guests, panelists, and moderators. Professors Choi, Arlen, and Miller are treasures to our law school, and we very much appreciate their participation. We have a wonderful lineup of speakers today. And this year's topic, as Dean Morrison said, is securities class actions in the U.S. Supreme Court case, Halliburton Company versus Erica B. John Fund. This symposium will explore the ways that Halliburton II changed the securities class action landscape, the debate over the role of the SEC, and potential legislative action on both the state and federal levels. Our panelists will present their perspectives on what Halliburton II means for securities class actions, whether the SEC should assert or be granted greater authority, and whether Congress will respond to recent securities law jurisprudence. There are 3 panels today, and they're all in your program, but let me just briefly go over them. The first one will be, which we have now, the status of the fraud on the market theory in securities class actions. The second one is the future of securities class actions. Should the SEC's authority under Dodd-Frank supplant class actions? And the last one is the effects of Halliburton II on plaintiffs, shareholders, and a potential legislative response. Please note that at the end of each panel, we have reserved 10 minutes for questions. Following panels 1 and 2, we will break for lunch at 12:40, and we will reconvene at 1:50 for our keynote speaker, Carter Phillips. So before we begin with the substantive part of the program, I'd like to give out a few thank yous. First, we'd like to thank Dean Morrison, our vice deans, the Symposium Funding Committee, because all of them support student-organized events. We'd also like to thank Paul O'Grady, Tracy Nwafor, and the entire Office of Student Affairs, who work very hard to help plan and execute the events that make NYU Law a special place. Third, the Annual Survey Symposium Committee, many of whom are in the audience right now, and our symposium faculty advisor and moderator, Professor Stephen Choi, who has been a tremendous help in planning this event with our symposium editor. And lastly, we'd like to thank Michael Roberts, our symposium editor. For the past 8 months, Michael has dedicated his time and energy to proposing, planning, and organizing this wonderful symposium. He has worked tirelessly with his committee to prepare every detail of today's event, and we wanted to thank him for his impressive work. And with that, I'd like to introduce panel one, the status of the fraud on the market theory and securities class actions. So I'm going to give a really brief overview of this panel, and we'll go down all the speaker bios, and we'll get started. So on this panel, because private class action securities lawsuits have significantly impacted the legal profession and the potential repercussions of Halliburton II, both plaintiffs, shareholder attorneys, and defense lawyers have reaped substantial financial gains in an extremely lucrative practice area. This panel will introduce the fraud on the market theory, judicial decision-making, and the aftermath of the Halliburton II decision. It'll also discuss the court's 2013 ruling in Amgen versus Connecticut retirement plans, where 4 of the 9 current justices, specifically Justice Alito, expressed concerns that the fraud on the market theory, that there was evidence that the fraud on the market theory may rest on a faulty economic premise. So our moderator for this panel is Professor Stephen Choi. He is the Murray and Kathleen Breen Professor of Law here at NYU Law, and he received his undergraduate degree from Harvard College and graduated first in his class from Harvard Law School, where he was a legal methods instructor and supervising editor of the Harvard Law Review. He worked as an associate at McKinsey in New York and then received his PhD in economics, taught as an assistant professor at the University of Chicago Law School, and then taught at Bolt as the Roger J. Traynor Professor of Law. He joined us at NYU Law in 2005. His research interests focus on the theoretical and empirical analysis of corporations and capital markets. He has published in a number of law reviews and has presented papers at numerous conferences and symposia. He's also received the Fay Diploma, the Sears Prize, and the Irving Oberman Memorial Award, and has also held John M. Olin, Jacob K. Javits, and Fulbright Fellowships. Our first panelist here is John C. Coffey, Jr. He is the Adolph A. Brill Professor of Law at Columbia Law and also the director of its Center on Corporate Governance. He holds a bachelor's degree from Amherst College, an LLB degree from Yale Law School, and an LLM in tax from our very own NYU Law. After graduation, he served as the Reginald Eber Smith Fellow, worked as a corporate lawyer for Cravath, and taught as a professor at Georgetown Law and then at Columbia Law. He's been repeatedly listed by the National Law Journal as among its 100 most influential lawyers in America. He served as a reporter to the ALI for its Corporate Governance Project, and as a member of the SEC's Advisory Committee on the Capital Formation and Regulatory Processes. He's written and edited several casebooks on corporations and securities regulation, and according to a recent survey of law review citations, he is the most cited law professor in law reviews over the last 10 years in the combined corporate, commercial, and business law fields. Next, we have George T. Conway III. He's a partner at Wachtell, and he graduated from Harvard College with a bachelor's in biochemical sciences and received his law degree from Yale Law School, where he was an editor on the Yale Law Journal. He clerked for Judge Ralph K. Winter, Jr. on the Second Circuit and is now a partner in the litigation department at Wachtell. He has broad litigation experience in the areas of securities, M&A, contract, and antitrust litigation at the trial and appellate and the federal and state levels. He recently briefed and argued the case for respondents in Morrison versus National Australia Bank, in which the U.S. Supreme Court held that Section 10B of the Securities Exchange Act does not apply extraterritorially to claims of so-called foreign cubed plaintiffs, foreign investors who purchase securities of foreign issuers on foreign exchanges. He also represented the Chief Judge of the State of New York and the New York Unified Court System in historic constitutional litigation over the state's failure to adjust judicial salaries. He helped prosecute one of the most prominent defamation cases in recent memory in Philip Morris versus American Broadcasting Company. And next we have Robert Fumerton. He's a partner in the litigation department at Skadden Arps. He received his undergraduate degree from Yale and his law degree from Columbia. At Skadden, he represents a broad spectrum of U.S. and international clients in a wide variety of complex corporate, commercial, and securities litigations. He serves on the firm's hiring and summer associate committees and was named as a 2014 Rising Star by the New York Law Journal. As an example of one of his cases, He, in 2011, won a complete dismissal of RICO conspiracy and fraud claims for Christie's in a highly publicized litigation brought by billionaire William Koch over the authenticity of wine that once belonged to Thomas Jefferson. He has also published several articles, including one which advocated a novel application of the PSLRA's bounce-back provision. Next, we have Adam C. Pritchard. He's the Francis and George Skistos Professor of Law at the University of Michigan Law School. He received his undergraduate and law degrees from UVA and an MPP from the Harris School of Public Policy at the University of Chicago. While at Virginia, he was an Olin Fellow in Law and Economics and an Articles Development Editor of the Virginia Law Review. After graduation, he clerked for Judge Harvey Wilkinson III on the Fourth Circuit and was a Bristow Fellow in the Office of the Solicitor General at the Justice Department. He was senior counsel in the SEC office, where he wrote appellate briefs and studied the effect of reforms on securities fraud litigation. He received the SEC's Law and Policy Award for his work in United States versus O'Hagan, in which the court upheld the misappropriation theory of insider trading. He now teaches corporate and securities law at the University of Michigan, and he's co-authored the casebook on securities regulation with Professor Choi. His research focuses on securities class actions, SEC enforcement, and the history of securities law in the U.S. Supreme Court. And last but not least, we have Robert Giffra. He's a partner in the litigation group and a member of the management committee at Sullivan and Cromwell. He received his undergraduate degree from Princeton University and his law degree from Yale. He also clerked for Judge Ralph K. Winter on the Second Circuit, and he clerked for Chief Justice William Rehnquist on the U.S. Supreme Court. He was named Litigator of the Year by the American Lawyer, has been named Litigator of the Week 3 times, and was profiled as one of the top 10 most highly regarded litigators by the International Who's Who Legal. He's represented prominent corporations and individuals in civil and criminal cases, at trial, in arbitration, and in government investigations. He served in all 3 branches of the federal government. In addition to his judicial clerkships, he was chief counsel for the Senate Committee on Banking, Housing, and Urban Affairs, and was a primary drafter of the PSLRA. He's also worked in the White House. And in New York, he's served on the New York State Commission on Public Integrity and on the New York State Ethics Commission. And with that, I'll turn things over to Professor Choi, who will be moderating this panel.
Great, thank you. Do you want me to stand up here or?
There you go.
Okay. All right. Well, thank you very much for those great introductions. I feel very honored to be next to all my very distinguished panelists. I'm here mainly just to keep the conversation going, which is really not necessary with these panelists. So maybe my role is actually to cut off people to make sure we finish on time. So let me say a couple things and then let's get started. So we know that public companies disclose a lot of information both through SEC filings as well as through press releases and conference calls with investors. A key goal of securities regulations is accuracy. How can we make sure this information, in fact, is accurate, credible, and so on. A key mechanism in the U.S. To help ensure, and there's some debate about this accuracy of disclosures, are securities class actions. In particular, we're focusing on securities class actions under Rule 10b-5. Now, with class actions, we know that common issues should predominate, and this is really the key question with Rule 10b-5. What about reliance? When we think about reliance, someone may disclose information, I may listen to it, it may induce me into a transaction. In some ways, it's sort of inherently an individualized sort of decision to do something or be induced into a transaction. How does this correspond with class actions? We know Basic v. Levinson gives us a presumption of reliance, and that brings us to Halliburton II, which is what we'll talk about today. So I have 3 kind of hopes in the discussion today. I'd like to talk a little bit about the aftermath of Halliburton II and maybe predictions about where we will be going. I'd like to talk a little bit about policy. Does this all make sense given that goal of ensuring accurate disclosure? And lastly, nuts and bolts. What is Halliburton doing? What is price impact? How do I show it? And what's happening out there? So why don't we get started? I will sort of ask some questions, but again, our panelists will probably take control over this discussion. I'll ask both sort of broad questions and maybe more focused questions, but why don't we start with a broad one? and panelists will just sort of jump in with their own views on this. So my first question is, given that we have Halliburton II, what's been happening in the immediate aftermath after Halliburton II in the courts, and what sort of are the predictions about where courts will be going with Halliburton II and this whole price impact concept? So anyone want to jump in?
I guess I can start. Before I say anything, I just want to put out a disclaimer that everything I'm saying is against my economic interest and my law firm's economic interest. I think that Halliburton II has been is sort of a ho-hum decision. It could have been a game changer. It is not. And in fact, what Halliburton II probably will result in is more money for lawyers and more money for economic consultants. I've been involved in a number of post-Halliburton II cases, and the net effect has been more money for lawyers and more money for economic consultants. I think the difficulty of Halliburton is this notion that you can basically get a consultant who can do a study, an event study, and really have a judge and maybe their clerks sort of make some sense out of what's in that event study, and you end up essentially with a battle of experts. And it's essentially just another sort of point where in these cases, which all settle, except for maybe 10 in history, it's just another point of leverage for the defendant or the plaintiff in terms of that settlement dance.
Let's go this way.
Yeah, why don't we just keep on going down?
So I think Halliburton is fairly characterized as a decision born out of ignorance, which is to say Chief Justice Roberts was pretty candid at the oral argument that all this economics stuff was too hard for him, which I do not fault him for at all, but then to send it to district courts on the assumption that it will be easier for them strikes me as misguided, and my prediction was that nothing would happen other than large bills for lawyers and economists, and I think that has been borne out so far. So it is a very ho-hum decision, but it is going to maximize billable hours.
Yeah, I mean, the decision's really, excuse me, more significant for what it didn't do than what it actually did do. It had the potential to reverse the Supreme Court's decision in BASIC, reverse the fraud on the market presumption, which would have essentially ended securities class actions. It also could have affirmed what the Fifth Circuit did, which was the Fifth Circuit held that you couldn't challenge price impact at all at class certification. So the Supreme Court has been kind of taking away weapons for defendants at class certification. Halliburton 1 held you couldn't challenge loss causation at class certification. The Amgen case held you couldn't challenge materiality at loss causation. The reasoning was that both of those elements go to the entire class, and so they don't bear on the Rule 23b3's predominance requirement. And then so now Halliburton has this essentially limited tactic to go after price impact. You know, from a strategic standpoint, I think the only benefit of challenging at class certification, obviously it's before the class is certified, before the pressures that Bob mentioned to settle are really exerted on you. And you also get an appellate right. So district courts, judges are immune from appellate review in securities cases because, as Bob said, they never go to trial. The only time you get to appeal is if you have a right and 23F gives you that right. The problem is circuit courts are loath to accept 23F certifications, and more often than not, when you challenge price impact at the class cert stage, you're just going to do damage to your ability to do the same thing at summary judgment and hurt your leverage going forward in the case.
Yeah, I think ho-hum is a nice word to describe Halliburton. I think it, in terms of its impact, to use that word, it's not going to have much of an impact. I don't even know what we're doing here.
George, we can talk about Morrison. That was an
Yeah, but
important case.
okay. And the fact of the matter is, as Bob points out, it's just, you know, it's not going to have an impact. It's not going to have an impact because the cases that don't have price impact are the cases that are going to settle, or going to settle for little small amounts anyway. And most cases that plaintiffs' lawyers do bring, there is price impact because they want to make money. They make money if the damages and the settlements and the judgments are high. And so they're looking to bring the cases, the bigger cases, the cases that don't really have a lot of price impact. And it's going to be, we'll talk about this more, it's going to be difficult for defendants with the burden to show lack of price impact, given the way event studies operate, which the Supreme Court was very much oversold on, thanks to your brief.
It's not my fault.
It's not going to have much of an impact at all. In terms of the economic ignorance, I think that's right. I think they did display economic ignorance in the first Halliburton case, where they said that, you know, they punted on the question of whether the Fifth Circuit was right that loss causation should be required as proof of loss causation had to be required for class certification. The fact of the matter is, loss causation is the flip side of price impact, which they ultimately, one other point about Halliburton is it actually, the result, the price impact holding makes absolutely no sense in light of Amgen. You cannot, I don't know anybody on this panel understand the paragraph, the two paragraphs in Halliburton 2 where Chief Justice Roberts distinguishes Amgen. I've read it 18 times, I don't understand it. He goes in, he says, he talks about what the plaintiffs argue, and the plaintiffs argue that price impact is no different than materiality. If there's no price impact, the whole class goes away. Therefore, it doesn't go to whether or not there are common issues predominating. And he says, EPJ Fund argues that much of the foregoing can be said of price impact as well. Fair enough. He agrees. And then he goes on and makes some distinctions that don't make any sense at all. So it's just a bizarre decision in that sense. In terms of the economic, to go back to the economic ignorance point, that's the reason why the court should have taken the invitation to not get into this altogether, because they created this right of, this 10b-5 right of action out of nowhere. And they would never, you know, it's accepted law today that you don't make up rights of action. Only Congress can do that. And then they gradually define the elements in a piecemeal way, actually mostly by lower courts, and no one ever looked at the whole thing as a whole, and the whole thing doesn't actually make sense. It doesn't hold together. Now, you may agree, you may think that it's better than nothing, which I think a lot of even the critics of the 10b-5 right of action would say, right? This man has said more about how 10b-5 class actions don't make any sense than anyone, and it may be better than nothing, but it makes no sense because the courts never understood it. They looked at everything piecemeal, case by case. No one ever understood the whole thing when they designed the various elements. And they're not institutionally capable of managing it. And so you're right. And so what we have is a continued muddle. We're going to have more of the same. Lawyers and economists and
Especially economists.
are going to make a lot of money, and shareholders, not so much.
The four preceding panelists have told you that this topic is boring and dull. I have learned, they're quite correct, but I have learned.
He can make anything interesting.
I have learned not to tell students that because they immediately fall asleep and start tweeting each other. Let me tell you that in defense of Justice Roberts, I think what he really decided in this case is that the Supreme Court is not a peer review board analyzing social science studies. It is a court of law generally following precedent. He has good reason for saying that, because if he overturned Basic versus Levinson, it's quite possible that his successors would start overturning all his decisions, and he doesn't want his decisions overturned, so I think he's quite committed to holding to precedent. Now, I think there are things that will happen at class certification motions. I think there are good strategic reasons for for defendants to raise class certification issues and to challenge it. You can win, not on price impact, but on whether or not the market is efficient. We'll get to that probably later. That's quite contestable, and the criteria in a case called Kammer versus Bloom are just economically primitive, but 7 out of 12 circuits follow the rule. So you can win on that. I think I just spent yesterday looking at all the recent district court decisions following Halliburton 2, and I have not found one that gave a victory to the defendants. There are
My
a
case
number.
settled, actually.
Oh, everything settles, we understand, but there are a number that have denied such a motion. What you can win on, and which defendants do contest more vigorously than price impact, is whether or not the market is efficient, what the length of the class period is. If you can shorten the class period, you can kick out half the damages, and that is worth fighting about. And always Daubert motions. We have Daubert motions everywhere, but if you can attack and compromise and discredit the plaintiff's expert, that's going to come up to haunt the defendants later on, because ultimately they have the burden of proof on showing loss causation, and the dirty little secret is loss causation is the same issue as price impact with the burden of proof reversed. You discredit their expert witness, they're going to have to settle the case, So there are reasons to litigate this intensely, but you just aren't going to win on price impact unless, on the date of corrected disclosure, the market price went up. And if it went up, there aren't any damages anyway. Why are these plaintiffs suing? So on that note, I'll tell you, we should move on and find other ways to discuss what's interesting in Halberton. It's not going to have an impact changing the status quo.
Well, let me, to keep the discussion going and save you some work, Steve, I want to ask a follow-up question. The plaintiff's lawyers like to say that there's all this language in Halliburton that minimizes their burden when it comes to showing efficiency. And so do you think that's going to have an impact on the camera factors?
Now, we're talking
and how
about,
courts do that?
proving loss causation?
No, I'm talking about efficiency, on efficiency. They like to point at some of this language in the opinion that says, oh, efficiency is not a big deal, it's we're just talking about really, really general efficiency, not really strong efficiency.
I have the view.
That's the plaintiff's lawyer's pitch, I'd like to.
I have the view, very simple principle, what's sauce for the goose should be sauce for the gander. When we get to loss causation, which is the same issue, plaintiffs are going to have to come forward with an event study meeting a 95% level of statistical confidence, showing that there was real losses caused by this misstatement. I think at the price impact stage, it should be the reverse of that. It should be reciprocal. The plaintiffs, the defendants are going to have to show an event study that there was no price impact, and it's going to have to meet the same level of confidence, and that's almost impossible to do. So I think it should be even, Stephen, in that regard.
Although it's not clear from the decision that defendants bear the burden of proving lack of price impact. They certainly bear the burden of coming forward with evidence to sever the link, but what the Halliburton argued on remand was that Federal Rule of Evidence 301, which applies to all presumptions, right, means that the party who gets the benefit of the presumption, if the opposing party comes forth with evidence, the ultimate burden of persuasion rests with the plaintiff in this instance.
Now, you may be right as to that, but most of the district court that have subsequently decided this issue have not said that. They said the burden on showing price impact is going to be on the defendant. Showing a lack of price impact, yes.
Yeah, the one issue that actually, that George raises, which is an interesting one, and I think it reflects the Supreme Court's lack of understanding of the way the markets actually work. Used to be, back in, say, 1988, when Basic versus Levinson was, I guess, enacted, we won't even call it a decision, most stocks were traded on, say, the New York Stock Exchange. That's not true anymore. And I had a case very recently where it involved a Canadian company. Some of the shares were traded in Canada, some were traded in New York. But even the shares in New York, only 20% of them were traded on the New York Stock Exchange, and the rest were traded on these things called dark pools. And so one issue that you could see litigated is the efficiency of dark pools, and it's obviously a way to shrink down the size of a class.
All right. Well, let me ask a follow-up question to this. And Jack, you sort of brought this topic up about the connection between loss causation, price impact, and we could even think materiality. So Amgen is about materiality, Halliburton 1 is about loss causation, Halliburton 2 is about generally this whole fraud in the market and price impact. If I were trying to show materiality in an expert report, I would take a look at the price drop upon revelation of the truth, and I'd look at this and try to figure out confounding information and pull that away and show, look, there's this statistically significant drop upon revelation of the truth at a 95% confidence level. If I were doing loss causation, I would do pretty much exactly the same thing. I'd find the price drop, I'd find confounding factors, and try to tease that out, find out what portion of that price drop is due to the alleged misstatement. With price impact, I think I'd probably do exactly the same thing as well. I would take a look at the price drop, find confounding factors, and take a look at what portion of that price drop is due to the alleged misstatement. Now, so a couple of questions. There is the possibility with price impact to look at the initial inflation. Is there some initial inflation? Well, that's difficult because lots of things were disclosed at the same time. But is that something you see? And the other deeper question is, if all three use the same thing, materiality, loss causation, and price impact looking at the price drop, is there any chance of confusion between these doctrines in the district courts? And have you seen anything in the district courts about how they deal with evidence of a price drop, and do they say, well, this is materiality, or this is loss causation, or this is price impact? And how have they sort of interacted, given that these are really very similar tests that are being used to figure out these concepts?
Well, I think one of the problems is that they are so interrelated. Where it becomes an issue in the real world is when you have the so-called disclosure of the information that was concealed with a whole bunch of other information, because most companies don't make one announcement on a day. So if you have a situation where a company announces one thing which people say, well, that's the information that was improperly concealed, and then 4 other bad things, and all of them cause the price of the company's stock to go down, the plaintiff does have some burden of trying to show that really the fraud was what caused, X percentage of the stock drop.
And this relates to how the Supreme Court was oversold by Professor Pritchard on what event studies do. I mean, what an event study is good at doing is figuring out whether or not on any given day there were excess abnormal returns, right? They regress the movement of the stock price against the movement of the general market and the movement of an industry index, and then they get the coefficients, and then they figure out, well, how much is beyond the range of sort of the normal random movement. And I think mostly, I mean, when I hire defense experts to replicate a plaintiff's event study, they usually are pretty good at it. It's not really, generally, two good economists doing an event study, fairly, are going to get pretty much the same results. They're going to identify the same days, except for days that may be around the margin, as to which days there was abnormal returns. That's not the thing. That's not where all the money rides on event studies. Where the money rides is on explaining why there wasn't a movement on a given day, or why there was. Why there wasn't a movement on a day. Yes, there was some fraudulent statement made that day, but there was some other confounding information that counteracted that. That's why you don't see that movement. On the other hand, if there was a statistically significant movement on a given day, somebody's going to say, the defense is going to say, it wasn't because of the thing that the plaintiffs are saying that was disclosed that day, because that was already disclosed, which is really a truth on the market argument, which is materiality. And the plaintiffs are going to say, no, it was this other thing. And whoever has the burden of proof is going to lose, as John points out. And take an example. What happened in Amgen? Amgen, it went up to the Supreme Court on materiality, right? Materiality, they said that none of these statements that were allegedly false were material because, that were alleged by the plaintiff were material because the truth was already known to the market. And they submitted a lawyer's affidavit attaching all the news clippings and analyst reports and whatnot that indicated that, according to the defendants, that the information was previously disclosed and that therefore the statements relied on by the plaintiffs were not material, truth on the market. Well, they lose. Case goes back on reconsideration for the court to deal with, the district court to deal with class certification. Now they're going to make an argument with an event study where the economists are looking at exactly the same things that were attached to the lawyer's affidavit the first time. Same thing. You may probably, except you're paying the economists as well as the lawyer.
But that's
Students, what you should learn from all of this is take a seminar on event studies. Stop taking those ineffable courses on international human rights. Take something that really matters. How do you do event studies? Because you're going to see it over and over and over again if you practice in the city.
And if you're a law clerk.
It's actually not, I thought it was the first time I sort of thought, oh my God, event study, I don't know any of this, I don't know. It's really not that hard. Buy Statistics for Dummies. As far as when you're going to practice law, all you need is Statistics for Dummies, and you will know enough about event studies to be able to pretend you know something. The Supreme Court apparently did not have this in their library.
And that's why I think district courts have got it wrong. I mean, for the relatively incoherent passage from Halliburton that George read, Justice Roberts, if it means anything, it means you can have an overlap in evidence, right? So the same evidence that you would show to defeat materiality can also be used to defeat price impact. And district courts who have interpreted Halliburton 2 have declined to hold that. But truth on the market, for example, is one of the most common ways that an economist will say, if the market's efficient, the market should already have incorporated this information. So if you can't show me new material information, it can't have a price impact. And for this doctrine to have any weight for defendants in securities class actions, it's going to take a district judge and, more importantly, an appellate court on a 23F appeal to hold that there's nothing wrong with an overlap in evidence between materiality, loss, causation, and price impact if it gets to the issue of negating that price impact.
There's a disconnect between how economists understand materiality, which is the consensus of the market is the equivalent of a reasonable investor, And judges do not want to be bound in making materiality determinations by the response of the market. So there are other things in materiality under the legal doctrine, management integrity, conflict minerals. Apparently the source of those is material for some reason, even if an economist could not find any price response to it. So the concepts are different. I don't know that they should be, but they are different, and the Supreme Court is making a logical distinction, even though in most cases the overlap of evidence means it's not a practical distinction.
But in the run of cases that we see, I haven't litigated a case in which materiality wasn't something that went to the price. Have you, Bob?
No.
No. It's always price. And and of course it is, because the plaintiffs want things that move the market, so they have damages, so they have fees.
Look, the most important thing in a securities class action is the motion to dismiss. The most important thing on a motion to dismiss is whether the defendants acted with scienter in making the alleged false statement. And in every single motion to dismiss that we all draft, that's the first point, and that's where the battle is fought.
Now, let's add the fact then, that looking across all circuits and averaging them all out, about 40%, depending on the circuits it varies, but about 40% of cases do get dismissed.
It's actually
at the-
higher now, it's 60.
Which circuit are you talking
I know,
about?
the latest Cornerstone numbers were that close to 60% of cases were being dismissed on motions in securities cases.
Well, then it's going way up. My point was that we have an awful lot of cases that are going to settle. These cases survive on settlement, and a case that survives a motion to dismiss has a very, very large probability of being settled.
No question.
Because it's going to be very expensive to take it all
Well,
the
the
way
really
through discovery.
interesting, the really interesting question that comes out of Halliburton, and it's sort of, no one ever does this, would be if a company had the guts to go to trial and lose, and you'd have a situation where the jury would say, well, the damages were the following amount per share, and then you would have a claims process at the end of the case.
That's what's
That's what
happening
happened
with
with Vivendi. It was going to happen in the household case in
Vivendi was a
Chicago.
billion-dollar judgment. She went to the jury.
And what would happen is, you could have a claims process where the defense could literally litigate plaintiff by plaintiff whether people actually relied upon the statements that allegedly were false, because it's a presumption, and you have the ability to overcome the presumption. And so, no one ever does it, because no company wants to take, no one wants to take the chance of, getting a multi-billion-dollar judgment.
Vivendi, the verdict came in, I think it was January or February 2010.
But it was about $2 billion, as I recall.
Yeah, well, I think the plaintiff said it was going to be about $9 billion, then it was cut back because of Morrison, probably to 1 or 2.
Yeah.
The claims process is still going on 5 years later. Now, you follow it. Yeah, it's going on.
Let me make another point. We're
Nobody's
saying
going to pay a
if-
dime.
But that's where
Bob's
Basic and
premise-
Halliburton could
but
actually
your-
matter.
but Your
in a claim.
premise
But nobody's
is,
gonna do that.
if the defendants had the guts to go to trial, you're skipping one factor, which is the judge. The judge may see at a class certification motion that he's got to decide at this point in the case for the plaintiffs and certify the class, because defendants haven't met the burden of disproving price impact. But he also sees it's a very messy body of evidence, and it's quite possible that later on plaintiffs won't be able to establish loss causation at summary judgment. That judge is going to want this case to settle. And a judge who wants a case to settle can bring great pressure to bear on both sides, and I think they do. I think they see messy factual cases,
I had a judge very recently, I won't name him,
or her.
or her, right, to protect the innocent, him, her, or whatever. And the judge, dismissed them, refused to grant dismissal and then set a trial date, like 4 months out.
We had a
And the judge barely wrote an opinion, and it was an opinion that was written and found facts against my client. And, the plaintiffs thought they were going to lose the motion. And he just wanted to get rid of it. And that's what happened. We settled it.
similar experience with a judge who shall go nameless. Before she had seen a single piece of evidence in her courtroom, she said, not only should these cases settle, they must settle, and I will do everything in my power to see to it that they settle. Which,
It's very easy to do. You just set a trial date 4 months out and say, no extensions.
and there's no appellate review unless you take it all the way through. Or you mandamus the judge, which is the same thing as the ultimate. Good luck with that.
So let me pursue this a little bit. So you guys have convinced me that Halliburton 2 is sort of ho-hum. On the other hand, you guys have told me that expert costs will be going up, lots of costs are higher, and settlements might be affected by this. So I guess that's the question. If Halliburton 2 is ho-hum, but it has an effect on settlements, is that important, or does it have this effect? So I could see effects for two reasons. One, if there are a lot of costs that could be avoided, assuming there are significant additional costs. The other one is the judge point, that if judges don't want to deal with this, will they put greater pressure for settlement prior to the class cert stage? So have you seen a change in settlement, both the incentive to settle as well as amounts, given the same
I
fact
mean,
patterns?
I had an experience very recently where we filed, a stack of papers that high with all kinds of expert reports in it. We challenged market efficiency because we made the argument that a lot of the shares were traded through dark pools, and the plaintiff had not shown that the dark pools were efficient. We had a situation where there were multiple disclosures on the same day, including the alleged, disclosure of the truth about the so-called fraud. And the case settled, within a matter. Oh, and I also made a motion, which I advise people to do now, for an evidentiary hearing at which these economists would testify. And I think that's a good thing, because how could a judge possibly get to the bottom of a stack of papers that are 2 feet high without having an opportunity to speak to the judge? And the case settled. Now, I actually saw the judge thereafter, and the judge said, I had this stack of papers in my chambers that was this high, and I really hoped you all were going to settle the case. And the plaintiff's lawyer obviously wanted no part of an evidentiary hearing at which the experts would all testify. The problem is, from a societal standpoint, you have to ask yourself the question, does this system make any sense? Which is ultimately, I think, the question that needs to be asked.
Well, I got just to give another example of a case that shows that I think personally, my opinion is that Halliburton doesn't matter even when it matters. I'll describe this case that I have that's going on right now, and I'll change the names and the facts to protect the innocent. But basically what happened is one Thursday last year, my client announced the settlement of a government investigation. And the only sanction was a few $1 million, an amount that was clearly immaterial to this client. And there's no question that it was immaterial. The stock moved a little that day, it went down a little, but if you do an event study, it shows it's not statistically significant. It moved a little, even less the next day, clearly not statistically significant. It's so bad that the plaintiffs rely on, that's Thursday and Friday, they rely on the following Monday, where the stock did drop in a statistically significant fashion. But the thing with the disclosure of the settlement, the government settlement, was so highly publicized, there is no way that you can argue with this New York Stock Exchange traded stock that was due to the announcement 5 days earlier. And in fact, there was some other news, confounding news over the weekend. This is a case, and there was no other, the announcement came in an 8K, there were no other confounding disclosures on the day. So this is the perfect case, if it doesn't get dismissed, which I think and I hope it will, for the defendant, for us to come in and say, here's our event study, don't certify this class. We should win that. But I don't think it's going to make, and if it comes to that, we will. But I don't think it's going to make any difference to the settlement value, because that case is weak anyway, and the plaintiffs know it. They know they're not going to get that much money out of that case, even if the motion to dismiss is denied, because there isn't any, there aren't going to be damages at the end. They could go to trial and get nothing. So they're going to take what they can get. And I just don't see the fact that I can make a motion, I can oppose class certification, is really affecting the needle.
Let me introduce a concept amidst this welter of detail and anecdotes that we're getting into.
Sorry.
No, it's interesting. But it is rational, it is logical for defendants to spend $2 or $2 million to cause the plaintiffs to spend $1 million, because there's a huge asymmetry in terms of the financial resources. On the defendant side, there's D&O insurance, and there's a deep, deep pocket there. If by putting in this event study...
Plaintiffs are entrepreneurs.
Let me just finish this little point. Even if you don't expect you're going to win at class certification on challenging price impact, you are raising the cost to plaintiffs who are litigating the case often on a shoestring. There may be 4 or 5 big plaintiffs' law firms that have deep resources The rest of them are litigating on a shoestring, and forcing them to spend money is going to change the settlement negotiations and possibly change the settlement that you can get away with. So that's one reason. The other strategic reason that you may want to make this kind of class certification motion is you get a preview of what's going to be the plaintiff's event study at loss causation, and you get a first shot at being able to discredit the plaintiff's expert witness. If you can damage the plaintiff's expert witness, or at least see ways that you can discredit him, you have a great advantage at summary judgment. And again, these cases tend to settle when the summary judgment motion is being briefed and presented. So that I think there are strategic reasons, because of cost asymmetries, that defendants do gain something from bringing these class certification motions that they don't really think they're going to win.
I'll go back to my anecdote. I mean, I have a big case out in California where we didn't make the price impact argument because we thought it was too easy. We would lose credibility before the judge. Now, we did oppose class certification on other grounds. We found some basis to that. But the plaintiffs did their event study. They had to do an event study anyway because to purportedly to show market efficiency. And they did have to hire an economist to do that. So I don't know if I agree.
But look, the problem with this whole area of law is that it is entirely judge-made. The problem is that the presumption in Basic, which people forget, Basic versus Levinson, 4-2 decision, which people often forget. Now, let's suppose the Supreme Court had knocked out the Basic presumption, and I think Justice Thomas has it right when he makes the point that whether Basic was right or wrong was really the court's decision to fix or error to fix. Congress presumably could have come up with a construct that made some sense. And I thought about it. When we did the Private Securities Litigation Reform Act, there's a safe harbor for it's near and dear to my heart, George. There's a safe harbor for forward-looking statements. That safe harbor was heavily negotiated with the SEC, plaintiffs' law firms, industry, and it has a whole series of carve-outs in it. So, for example, the safe harbor doesn't apply to statements in financial statements. And it's a very clear sort of legal regime laid out in the statute. What you have here is something where the courts essentially just punted to a bunch of economists. And so the problem with this entire area is it's judge-made law with a judge-made presumption where now we have sort of economics being injected into it. And the point that often gets lost is that when Congress enacted the 34 Act, it actually did have a private right of action in it, Section 18A, which basically allows for claims based on false statements in filed documents with the SEC. And that provision has a reliance requirement, something that was added to it during the course of the legislative process.
It's even worse than that. I mean, there are the defense and the pro-defense amicus briefs in Halliburton, of which I submitted one. We said that Section 18 was the closest analogy. Section 18 allows people who buy in the secondary market to sue issuers for false statements in written disclosure documents. And
So Congress thought about this issue and passed a law.
It has a reliance requirement, and you look at the legislative history, some people said, well, you shouldn't make them prove reliance, and the congressman said, no, that's crazy. We'll have crazy litigation. The plaintiffs, on the other hand, argued that Section 9 was the closest analogy, because Section 9 deals with manipulation. It doesn't require reliance. But Section 9 requires privity. Congress thought about all this in 1933 and 1934. And they didn't conceive of Section 10B having some kind of a Section 10B, an implied right of action where you don't have to have privity and you don't have to have reliance. And that's what we have today with Section, and that's why it's such a powerful weapon, and that's why, basically it is the largest, if any provision in the U.S. code, other than the tax code and maybe the antitrust laws, it is responsible for the largest transfers of wealth. And there's no basis for it in the statute. And in fact, it confounds the original intent of Congress, which actually wanted to have either privity or reliance.
See, it all really goes back to 1966 when Congress basically, when Rule 23 was put in effect to allow for, you have to opt out of class actions rather than opt in. And so once you had the class action device, if you were to require, as one would think, well, let's require reliance, right? If you had to show reliance on a class-wide basis, you couldn't do it, so therefore you couldn't bring securities class actions and what they became by 1988. So that's how, you know,
And
that's how,
Basic was
that's
brought
how
about.
Basic came about.
All the Court of Appeals cases that came before that, Blackie, they all basically said, well, you know, if we're gonna have a class action, we shouldn't have Reliance.
But the question really should be, well, why
And they were
doesn't
making the
Congress do
policy
this?
judgment.
See, that's the real issue. Why doesn't Congress do it? And in fact, and Congress actually could, like it did for the safe harbor for forward-looking statements, lay out a very clear regime saying, for example, if you're a day trader or someone who's a computerized trader, you know, you don't get to bring a, you
It's
don't get to
hard
bring
to
a claim.
imagine that Congress ever would have voted the current regime into law.
So-
Now the burden is for Congress to vote it out of law.
Which will never happen.
And, you know, I mean, I appreciate, what John pointed out, as Chief Justice Roberts is concerned with stare decisis, which applies, he's right, that it applies particularly strongly with regard to statutory construction, because Congress can rewrite the statute as opposed to constitutional, and he also wants to save his power for overruling bad constitutional decisions. But the problem is, this was not a construction of a statute. This isn't like interpreting Section 5X Roman I-A of the Migratory Bird Protection Act or whatever, and the question is whether, for it to be migratory, a bird has to cross 1 or 2 or 5 state lines. And Congress might pick 4, so you might say 2. This court might pick 4, you might pick 2. Congress can fix it. You can decide to be 3. This is a situation where much more expansive, much more incredible.
You have an implied right of action in the face of an express statutory provision.
Created this massive industry that made Bob rich.
This is not a question of statutory interpretation.
You too-
Halliburton
you
has
too,
nothing-
George.
Halliburton has nothing
Not
to
so
do with
much.
statutory interpretation. It's a question of institutional competence. Chief Justice Roberts does not care what 10b-5 says or Section 10b says. He is not equipped to deal with this.
That's right.
And therefore, he is going to
So
be
therefore, he's going to make all the district judges deal with it,
Well, no, in
who are
his,
no more competent
in
than
his
it.
vision, Congress is going to deal with it if it is
Yeah, right.
to be dealt with. I think the construct of creating this industry has created interest groups on both sides that means that nothing will happen, because Congress had a chance to do this in 1995. The question of dealing with Reliance was raised and nothing happened.
Yeah, no,
Defense
it-
lawyers were
the-
secretly relieved when they saw the Halliburton.
No, what happened with the PSLRA was that was a law that literally passed on a veto override. Hasn't happened very many times. And actually, Teddy Kennedy, John Kerry, Dianne Feinstein, they were part of the veto override of President Clinton's bill. That bill was like the most heavily negotiated bill, you know, in memory. And that if you changed a word in it one way or the other, it wouldn't get the necessary votes. Now, what's interesting about the process with respect to this issue was this was a third rail issue, whereas if, half the people wanted to overturn Basic and the other half wanted to codify Basic, and so therefore you ended up with nothing.
Let me follow up on this point, this interesting point you made that defense attorneys were secretly happy about the Halliburton decision. And I notice we have a bunch of defense attorneys here. We don't have any plaintiff attorneys on our panel. So let me channel my internal plaintiff attorney and say that, class actions, despite the history here, which may be sort of a judicial tree out of this legislative acorn, that securities class actions are important. We need these to enforce the securities laws, especially with respect to accurate disclosures. So my question to everyone is, what is the alternative? If we could go back and ask Congress, and if Congress were to do something, or the individual states, how would you fix the system?
Oh, you've just thrown a gopher ball to me. I've got a book coming out in 2 months that's going to try to address that question. All right? It's called Entrepreneurial Litigation, Its Rise, Fall, and Future, Harvard University Press, out in June. I'll get you a discounted copy.
I love the title.
Advanced sales at the door.
The title is great.
Right, let me-
Entrepreneurial litigation.
That's what we're
It's what
doing.
it is, no
Okay.
question.
The lawyer hires the client rather than the client hires the lawyer, et cetera. Now, in this world, what would you have to change? Well, first problem is something that's called circularity. This is shareholders suing shareholders. The class that's within the class period is suing all the other shareholders, and that means we're getting wealth transfers, and there's very little possibility of any kind of compensatory benefit from shareholders suing shareholders, because whatever recovery there is immediately reduced by both the lawyers' fees
Current
for the
shareholders
plaintiffs
going- given
and the
by old
lawyers' fees
shareholders.
for the defendants.
Lawyers, economists,
But now,
insurance.
other costs are there too. Now, there still could be a justification, there's a deterrent benefit. But here's what I think is interesting. You've all heard the critique, which Judge Rakoff is particularly well made, that public enforcement today produces only deferred prosecution agreements that don't do much, a slap on the wrist, or a large penalty on the corporation, which is again borne by its shareholders. No responsible officer ever gets sued by the SEC or other public authorities. Very few individuals have been held accountable. It's even worse, however, when you move over to private enforcement. When you move over to private enforcement, we find that there is both D&O insurance, and almost always 99% of the settlement is paid by the corporate entity, nothing by the individual officers, and if they were paying something, it would come exclusively out of D&O insurance. So the world that Rakoff talks about in terms of public enforcement is mirrored and aggravated when we get over to private enforcement. How could you change that? I would point you to what Canada does. Canada puts a ceiling on the maximum damages that a defendant could be liable for. You can still have the suit for symbolic, retributive purposes, but you won't get much damages. I would couple such a ceiling on the corporate liability with, this is where the rest of the panel is going to be shocked, with repealing Central Bank of Denver and restoring aiding and abetting liability. There are people who are culpable out there, and sometimes they should be sued. If private enforcement is going to do anything meaningful, the basic Missouri Compromise should be reducing the corporate liability and bringing back the idea of individual liability. Now I turn it over to a panel of four who think that's the worst idea they've ever seen.
But you also want to get rid of insurance, right? Or limit insurance reimbursement of.
See, you know, one of the,
Their insurance doesn't cover certain kinds of culpability.
Culpability, right, well, after a judgment.
But then you'd have a talent drain of D&Os in public companies.
But let me just.
I don't know that you're going to people fleeing being a CEO. I really don't think.
Yeah, but I
CEOs
think
are-
you're losing sight of the most important thing. I don't think anyone who's sitting there committing securities fraud in a gross way is thinking, oh, you know, 5 years from now I might be sued in a securities class action. Oh, I'm not going to commit securities fraud. I think the deterrent for people to commit securities fraud is putting people behind bars. And in fact, there have been situations like that. Richard Scrushy, Health South. I was involved in that case. I saw the guy show up at a deposition in literally shackles. Sanjay Kumar, Computer Associates, in jail for 10 years. The WorldCom, Bernie Ebbers, I think he may be there for life. Bernie Madoff is definitely there for life. So if you want to deter people, you actually should, you know, you put them behind bars. The second thing that is worth noting is that in enlightened Europe, okay, we always think about that's the most enlightened place. They look at us and they think the securities class action system is complete and utter nuts. Absolutely. And in Europe, there are no securities class actions.
Well, there are
and they
some.
have markets that are that work.
Start.
They have people raising capital. And you know, in terms of a solution, the one that probably makes the most sense, and this is maybe shocking too for me to say, would be to give the SEC more of an ability and the DOJ to actually go out when they're in the process of investigating one of these frauds to get the money from, you know, the you know, bad actors and then distributing it to the shareholders.
They're not interested in that, right? The Ebbers cases, that's the tail end of the distribution. What
But that's
the
a real
SEC
fraud, though.
It is a real
That's,
fraud.
and a lot. The problem is in this whole area, you sort of have the Ebbers cases and the Sanjay Kumars and people like that, Bernie Madoff, where there was clear fraud. Most of these cases are in the middle zone, where you have a real argument. You know, was there a fraud? Wasn't there a fraud? What was someone's state of mind? Was this really just a bad business deal gone wrong? And you know, you don't want to put people in jail in that situation. And
The
that's part of-
SEC's incentive is not to bring individual enforcement actions, because they're not going to get bigger headlines, they're not going to get bigger penalties, which is what they are interested in maximizing.
Right,
So
but-
redeploying is simply duplicating the problem.
Absolutely right that securities class actions don't have much deterrent effect because of the insurance and indemnification, and because of the fact that the way that corporate executives look at it is like you can get sued no matter what. Okay, there's nothing we can do about it, and we have insurance.
Probably
In
most.
terms of enforcement, even though few individual actions are few and far between, and some people may say, as Rakoff does, there should be more, that does still have a real deterrent effect, because nobody wants to be the
But
target
let's make
of
sure we
an
get the issue
investigation.
joined here. What I'm saying is, if there is a rationale for private enforcement through securities class actions. It has to be through the deterrent benefit that you could gain by restructuring it. You do agree that there is no compensatory value to pocket-shifting wealth transfers between
Absolutely, and I
shares.
would go farther than, I'd make a couple of additional points to the ones that John made. Okay, there's the pocket shifting. The pocket shifting actually is from smaller shareholders to larger shareholders for a
Yes,
couple of
it's
reasons.
hedge funds that get the money,
Exactly.
and
The
it's the retail
hedge funds are
shareholder
more
never is in the
active.
class period.
The grandma and grandpa who sit on their savings and aren't day traders, they don't have any transactions to recover on. Not only that, they're less likely to submit the claim form than is the hedge fund who has 1 million shares. Beyond that, the plans of allocations, most of these cases settle, as we all know, the plans of allocations basically have no relationship whatsoever to damages.
No, they favor the lead plaintiff.
Absolutely right.
Shocking.
Absolutely right. So, it is,
Notice there's no plaintiff's lawyer on this panel. There is something that could be said by someone else here, who's not here.
But again, actually, you have to remember, our economic interests, Bob and mine and my friend from Scotland here, are all, aligned with the plaintiffs on this. Because we make money off of this, litigating these cases.
You've heard consensus on only one
You-
thing.
you may all
There's no
too, some of you
compensatory rationale for the current system. There may or may not be ways to get a better deterrent benefit out of the securities class action if it were reconfigured.
But John, there are no securities class actions in Europe, and they have good markets, by most people's account. London, the
That's
London
a
markets
long,
are
involved
good.
question. That's a little too glib a generalization about the European securities markets.
But I think no one would say the London market wasn't a good market.
London's
But
different.
let's say the Supreme Court had wiped it away, overruled BASIC, sent it back to Congress. Congress would have, in fact, done something, and they're not real imaginative. They would have probably copied Canada because it would be at hand. They can't say there's going to be nothing because there was something. It's a good argument that there should be nothing, but, that's not really
It's-
politically relevant.
It's a funny, I worked in the courts and I worked in Congress, and yes, the people in the courts are way smarter and more honest, and it's just a great place. But there's something kind of strange about the fact that, you can be sitting there if you're a law clerk, and then the judge marks up the opinion, and that becomes the law, as opposed to a process where literally it's all out in the open. The SEC can comment on every single line in the statute. The plaintiff's lawyers can comment on every single line in the statute. The industry groups can comment on it. Academics can
And
comment
you're
on it.
looking at the whole thing as a whole, as opposed to making piecemeal decisions the way the courts have made over time as to, well, what's this element supposed to be? Should there be this element? And not fully appreciating the monster that they created in 1988. Absolutely right.
So let me come back to channeling my inner plaintiff attorney, because I feel like they are being underrepresented here. So to the argument that, well, there's no deterrence at all, well, if that's true, then it's really, there's no reason for any of this. But let's assume that in our current world, we observe this because the counterfactual world, if there were no plaintiff attorneys, maybe the amount of fraud would shoot way up, and it's hard to know what that would look like without plaintiff
But
attorneys.
I've been practicing law for doing this kind of work for 25 years. I have never worked on a case where an individual defendant paid to a securities class action settlement. It was always either the D&O insurance, and that's, the vast majority of
Yeah.
cases, or it's maybe some money from the company if it's a really bad
No,
situation.
I agree with that. And I think actually expanding liability to the individuals would be a very important and interesting thing to do. I guess my question is if we're
You're
thinking...
agreeing with me. Good
Yes,
heavens.
I
Good
always
heavens.
agree with you. But my question is, I can understand if compensation really doesn't work very well. But what about this argument that plaintiff attorneys are doing this public service? There are these private attorney generals. And the real thing we want to do is pay them. So the proposal would be, let's eliminate compensation and just make sure there's a bounty for the plaintiff attorneys. If you think what they're doing is a good thing, let the plaintiff attorneys get money from the individuals, let them get them from the company. So we want to retain the company payment because that payment is the monetary incentive to give the incentive for plaintiff attorneys to bring these great lawsuits. Again, if you don't believe plaintiff attorneys are doing anything, you won't agree with me. But if you think there's some deterrence, why not justify the system we have
Because-
as paying the plaintiff attorneys?
Because then you end up punishing the people who you're supposed to be protecting, namely the shareholders, because the shareholders
Well, now,
ultimately pay for it.
But here's another
But that's-
possibility.
okay, so-
Following up on your suggestion, you want to do something with the plaintiff's attorneys. one of the things you could do is have public enforcement agencies hire them. We do see the bank regulatory agencies doing this. The FDIC does it all the time, and they get huge recoveries for the FDIC.
The FHFA?
If the SEC is not doing enough, which is what Judge Rakoff's point is, and I think there's a lot of evidence for his point of view, one of the things we could do is begin to have public enforcement agencies hire plaintiffs' counsel on a contingent fee basis. Might take some change in the law, but I think you would see a very different kind of enforcement.
Well, actually, in the FHFA case, where they've
Yeah, they
recovered
do.
literally
The
billions
FDIC
of
does it even
dollars,
more.
billions of dollars, my understanding is the fee arrangement was an hourly-based fee arrangement.
They have some that are on success fees, too. They try to avoid the word contingent, but they have success fees.
I think the answer to, having the money be, basically having, however you want to do it, having the government do it, is there's a duplicative process that goes on here, because take the Enron case, for example. The government investigated the heck out of Enron. Then Bill Larac came in behind that and essentially piggybacked on the government work and then did a settlement. It would make more sense to have a system where there was public enforcement if there's going to be public investigation.
I think public enforcers often are bureaucrats. We could get the private profit motive into this
I don't think there's
process.
anything stopping. I mean, state attorney generals can hire private counsel all the time.
And they do.
The banking
And it
agencies
works.
did. Yeah, they got huge settlements in some of these cases.
But we're trying to find a role for the plaintiff's attorney that is more successful, creative, and socially beneficial. I think we can create that kind of role. This is chapter 10 in the book I just described to you. Okay.
Go to Amazon.
So everyone should buy this book.
Not till June, not till June.
Not to June. So let me continue on with this policy discussion, which is very interesting. There's a lot of discussion about the fact that the way the law here develops is just piecemeal, case by case. Judges don't really know what they're doing developing this stuff. So if we take it back to Congress, what exactly would we change? Besides, we could eliminate the entire private cause of action. Would you change other aspects of 10b-5, damages aspects, anything along those lines?
If we didn't get rid of it altogether, I would get rid of it altogether, but if we didn't do that, I would impose a damages cap like the one that John referred to in Canada. In Canada, it's $1 million, either the greater of like $1 million Canadian dollars or 5% of the market cap. Yeah, I think restricting the amount that could be recovered would make a lot of sense. At least it would impose fewer costs on shareholders.
And you can do an incremental change, but what Robert suggests in the opinion is to place the burden squarely on plaintiffs to establish lack of price impacts or to establish materiality loss causation. Congress could do any one of those things to tweak the basic presumption to make it more difficult for these class
Now,
actions.
Congress could, but I think we're romanticizing Congress. Yes, they did it once when they were commanded by Mr. Juffra on the PSLRA, but
Actually,
otherwise...
you know what we did in that law? One of the best provisions in the entire law is the lead plaintiff provision.
Yes.
The lead plaintiff provision came into effect because I'd gone to Yale Law School, I'd come to a meeting, and there was all this discussion about how are we going to deal with monitoring plaintiffs' lawyers. I went back to my office, and I got the page proofs of an article written by Elliot Weiss. Elliot Weiss. I'd gone to Yale. I thought, I better read this. And I'm reading this law and economics analysis, which says, well, let the plaintiff that has the biggest loss control the case. Sort of made sense to me. So we drafted it up. It was never the subject of any debate or anything else, and it was in the law, and it actually works. So see, academics, this is the best way, other than doing a really good amicus brief, that you can actually affect the law.
But remember,
Your book,
Congress doesn't usually act. We've had Congress trying for 30 years to adopt the definition of insider trading, and I'm now working with a committee that's trying one more time, and I'm not predicting that
Well,
it'll
that's
be
going to
very
get punted
successful.
potentially to the Supreme Court, too.
I mean, this statute passed at the one moment in which we had a complete political landslide and created the momentum for the PSLRA. I think we have a very polarized Congress, and I think we're romanticizing things if we think Congress is
Oh, I don't
going
think-
to be
That's
able.
absolutely right. It's like.
No,
it's
I don't disagree.
Absolutely right. I mean, it just happens, you have statutes that pass very sporadically. You had Dodd-Frank, which was just, again, just
After a
moment-
crisis.
After a crisis, and the political stars just aligned for a brief instant, and then they made it a 2,000-page bill or whatever, because they got everybody's wish list in there.
The one
And not a
change
great
I would,
statute.
the one change I would put in the law that should have been put in the law and wasn't, is that these cases really do turn on who the district judge is who has the case. Some district judges are pro-plaintiff and some district judges are pro-defendant. And when they are dealing with these motions to dismiss, which are the key sort of linchpin point in these cases, if you get the wrong district judge, that can affect the value of the case. So I would have a provision that would allow for the appeal of the denial of a motion to dismiss in a class action.
I think that's a great idea, because again, I mean, it's not just that some judges are pro-plaintiff and some judges are pro-defendant. I think there are a lot of judges who are, on balance, don't want to create appealable orders in which they get reversed. And that would help too. This way, they have to, one way or the other,
Yeah, but
they're
if
going
they
to
face
have to go up.
reversal,
Right, so they have to actually decide.
I mean, the
to get it right.
PSLRA has eliminated a lot of the real abuses that existed in the law. I mean, you used to have a situation where, Mel Weiss and a few other lawyers literally had, 5 in-house plaintiffs who owned 5 shares of stock in every company. There was a race to the courthouse. Whoever filed the first complaint, the complaints would be literally filed like the next
Steiner,
day.
Mr. Cooper.
And you could start the discovery clock, from day one. So companies would settle because they didn't want to spend millions of dollars on discovery. And with the PSLRA, one, you have the lead plaintiff provision, which puts at least some adult supervision on the process. 2, you have a heightened pleading standard. You have this protection for forward-looking statements, and you have a discovery stay. So there are provisions that make the system a little bit more sensible.
There's a coherent regime lurking in 10b-5. If the damages measure were fixed, it should be disgorgement. Section 18 requires actual reliance to get compensatory damages. Everywhere else, if you can't show reliance, you're limited to disgorgement. If the damages measure were disgorgement, you would have no reason to sue the corporation. The only recovery you could get is from officers and directors who actually engaged in the fraud. The point of the enterprise should be deterrence. All of this stuff about materiality and price impact and loss causation serves no socially useful purpose whatsoever. Every dollar spent on price impact and loss causation is a dollar that society is wasting. The only question that matters is whether or not fraud occurred, and clearing the decks with a disgorgement measure of damages of all these other issues would channel the system toward that question.
So on that basis, you're telling the rest of the panel they should give back their salaries for the last 20 years.
Well, they're parasites.
And we are honest parasites, though.
They
Bob, we're
acknowledge
all
that.
honest parasites. We want to litigate some other kinds of cases, like your wine case. I want to litigate your wine case.
So let me keep coming back to what a plaintiff attorney would say. So I hear proposals capping damages, proposals to keep things to disgorgement, but as a plaintiff
I
attorney...
want to restore aiding and abetting
Yeah, so
liability.
you're also channeling the inner plaintiff attorney. But so what I'm concerned about here is, again, if the plaintiff attorneys are doing something which is good for the shareholders by providing this deterrence, and again, that we can question whether there is any deterrence, I want all these efforts to reduce damages, to disgorgement, to keep things capped. I want this sort of reduce the importance of private enforcement.
Here's a great plaintiff's attorney just walked in the
Yeah,
room.
he should have
Yes.
been. He should have
He
been
should
on
have
this
been on this
panel.
Yes, he should have been on this
In
panel.
fairness, you should
Max.
come up here and argue with
Yes.
us. Right
Max,
now.
get up here right now.
Perfectly. And we were just talking about the lack of balance on this panel, and there you are.
I think he's on panel number 2. So
Okay, we don't want to steal his thunder.
yeah, so I'll keep channeling. So, and I guess the question I have is with respect to smaller public companies. So larger public companies, we have a great ability to show efficient market, but what about the smaller companies?
It's a very good point, because the fraud on the market doctrine essentially immunizes the smaller company at the bottom tier of NASDAQ and below. And the classic American scam is the pump and dump scheme. But the pump and dump scheme is probably beyond the reach of most class actions because the market's not efficient. You can have individual suits, and I have to say, in the world of institutional investors, they don't really need the class action. They can sue on a consolidated basis. But the classic American scam is beyond the reach of the securities class action, and that's one of the problems of the strange arbitrary line that the fraud on the market doctrine creates.
That's a good point.
So I know the rest of the panel, I guess the observation is we have too many class actions for the large public companies, too few for the small ones. It's very hard to show efficient market for small companies. They may have more room as a result to pump and dump and do what they want.
On the other hand, let me make one counterpoint to that, is smaller companies are companies whose stock tends to be more volatile. And in cases that aren't real frauds, allowing class actions against them, could put them out of business. And we have to be very careful about that. They're the ones who might not be able to afford the insurance. They might not be able to afford litigating these things. We put them out of business.
And might
They're
keep them
high-risk
honest.
Propositions might keep them honest, might make people less interested in starting up public companies.
I don't worry about that. This country has a lot of motivation to be an entrepreneur.
Well, why do we want to take it away?
thoughts
Are
on
we
this?
done?
So we have I think we're approaching the question and answer session. So I've been asking lots of questions. Why don't we open this up, and I can continue asking questions, but why don't we get some questions from the audience then? Yes.
There's been a lot of talk about insurance and how the existence of D&O insurance kind of skews the accountability component of securities class actions. Given that it's unlikely Congress will act, and we already know the Supreme Court won't act, is there some way that change could come through the insurance industry and insurers becoming more reluctant to, sponsor insurance for fraud? Well, they don't.
It's a very profitable business.
Is
so
this
that's-
on the record?
You're being videotaped, so yes.
All they're going to do, they're just going to raise premiums.
Yeah.
And that they're making that judgment, their economic judgment based upon the loss history, and that's the way they respond to it. They're
the
not going to
problem
stop
is-
writing policies if they can get people to pay the
And
premiums.
It's
the problem
also
is if
true
you-
that
if you
the
were to say-
insurance industry is not risk adjusted. They're charging premiums without regard to the company's relative blameworthiness, relative risk exposure. They're spreading it broadly over shareholders as a class. So it's not working the way insurance is supposed to work in economic theory.
And I also don't think D&O insurance is necessarily a bad thing here. I mean, if you're really going to tell people they have to put their entire personal wealth at issue every time they serve on a company's board or to be an executive of a company, you're going to have a huge talent drain in the executives of public companies. I mean, that's not what we need.
Well,
We
I
need
think
more-
you were right when you talk about the outside director. I'm really not worried about CEOs fleeing the board. I don't think that's going to happen.
Right, if you-
Compensation
if
is
you
more
have
than sufficient.
no cap on their liability and no insurance.
The insurance
It's gonna be a
regime is
pretty
a
risky
scam.
No, it might keep them honest.
The directors are driving the purchase of the policies because of a virtually non-existent risk that they would be held liable. Because in order to be held liable, you have to make misstatements on behalf of the company, and most directors are not in a position to do that. The misstatements are being made by the officers. The officers really need that insurance, and the reason they can persuade the corporation to purchase it is because it's also covering the directors.
I mean,
So
what's-
it's
Now, on the next panel, Max Berger can talk to you about the WorldCom case and how they took the life savings of the poor outside directors there. It's a very interesting story, although it's a one-of-a-kind story.
I mean, the one important point to keep in mind is that, and I think John had an excellent point when you talk about disgorgement. Disgorgement measures of damages make a lot of sense, but if you have a really big fraud, WorldCom, HealthSouth, Enron, the executives who are involved in that fraud, they will end up having their assets, disgorged. The government will want it in restitution. And so that's why ultimately it comes back to, 'cause typically what happens, if you have a company that kind of goes poof and blows up, then new people come in and take it over. There are people who will, see can the turnaround work? And then that becomes a cost of the turnaround, the settlement of the case. I've always believed that, if you have bad actors, you should try to get every, last nickel from them you can. And when I worked on Computer Associates, we tried actually to do that with respect to Sanjay Kumar, but the government actually was negotiating their own settlement with him, which allowed, his wife to keep a certain amount of money, and then they basically told us to pound sand. And that was when I represented the company, and we were trying to get back the money that we had advanced to him in attorney's fees.
Other questions? Yes.
I just wanted to follow up a little bit on the issue of market efficiency. Professor Coffey, you mentioned about small cap companies with the lack of market efficiency, and then Mr. Gifford, you mentioned a recent case involving black markets. And I was just wondering whether, how much more viable challenging market efficiency has come post-Halliburton. I mean, is it a strategy that's just not pursued, or is it?
They're still using the same district court decision, Kammer versus Bloom, that
New
lists
Jersey.
5 factors, most of which have no economic sophistication at all. This is one of the few issues that could still go to the Supreme Court. What is the definition of market efficiency for purposes of the fraud in the market doctrine? I'm not saying it will, but it
They'll
could.
do a great job with that.
I mean, I think it could become more of an interesting area with, the rise of dark pools and the decline of, organized markets.
Well, you know, for example, IPOs don't trade in an efficient market because the underwriter and the issuer sets the price. So that's one of the arbitrary features of the fraud in the market doctrine. It can only reach the IPO after the end of this quiet period when the analysts get back into the field. So we have a very arbitrary line on the fraud of the market doctrine.
Heather?
Yes, I have a question about you discussing public agency employing private attorneys to help them out to get, money recovered. But we know about scandals like IRS uses a political police going after conservative groups, or Department of Justice not being completely employed in a kosher way. Can we trust government, especially since next presidential campaign power will be more than $1 billion? Can we trust them in terms of enforcing the law, in terms of how it should be enforced, instead of engaging in political vendettas in order to get financial advantage for political candidates? Thank you.
So this is an important question. Let me just continue on with this. There's a lot of discussion about, well, let's bring in the SEC. They'll solve all these problems. But what about problems within the SEC? Are there political things which drive SEC attorneys, lifetime concerns? Can I get a job at an investment bank? So if we're going to put a lot of stress on the SEC, either under Jack Coffey's proposal or generally let's have SEC do more enforcement, what about this criticism of the government enforcement attorneys?
The problem with, look, I think I have a lot of respect. The U.S. attorney's offices, and maybe this is because the people who are, you sort of learn you're doing real crime, and you're involved when you first start in the U.S. attorney's office, drug crimes and gang crimes and organized crime, and then you move up to white-collar crime. They really can focus on, what really is an important matter and what's not an important matter. My criticism of the SEC is that I think there's not enough direction, and maybe it's changed in the last few years, as to trying to figure out what are the cases that really matter and what are the cases that don't really matter. And they spend a lot of time on the cases that just don't make a lot of sense. I mean, and I have to be careful what I say. It's been reported in the press that there's a whole big investigation into hiring practices in China, okay, as an FCPA matter. When you actually stop and think about that, does the U.S. government care about, what banks are doing in China with respect to, getting business? That's not, it's kind of a little bit off to the beaten path as opposed to something like, are people engaged in, accounting statement fraud, a Madoff-type situation.
But the China situation was reported in the newspapers, so therefore it is in the
Absolutely
interest
right.
of the SEC.
Absolutely right. If it's important, they're driven by headlines, and they pursue cases, they miss cases that they should bring. Madoff was a great example. And they bring cases, they get obsessed with cases that are worthless.
Well, actually, maybe the point is they tend to be driven by what's actually presented to them in the press as opposed to ferreting out problems, before it becomes a public issue, like a Madoff is a perfect example of that.
I'd give a slightly different interpretation. The SEC, much more than the Department of Justice, has to deal with a hostile Congress and get a budget each year, and that requires them to constantly show that they are bringing more cases and getting more settlements, and that produces an emphasis on bringing relatively small, unimportant cases so that they can keep those numbers constantly rising and justify a higher budget allocation. If you look at a chart, a pie chart of the cases they bring, about a third of them are late filing cases. Another 20% or so are cases involving follow-on actions, where someone else has levied a sanction and now you're throwing them out of the industry. These kind of cases are only explainable by the bureaucratic need to show constantly increasing volume. That's not, I think, the way the SEC should be allocated. They should be like the Department of Justice, focused on who are the worst criminals, who are the worst bad guys out there. I can't say that explains the SEC
Well, when you think about
allocation of effort.
when you think about the DOJ, you actually do have situations where the DOJ will investigate something, there'll be some, indictment, and no one even knew that there was a crime that was going on. The SEC, for the most part, is really basically a copycat agency in terms of what it looks at.
So that's a little bit pessimistic then about diverting more enforcement to the SEC.
Well, but
No,
plaintiffs' lawyers,
even,
private attorney
the
general
point
is
is, even
entrepreneurially
in its
Yes,
randomness.
I don't know which is better, I guess.
I mean,
Even-
plaintiffs' lawyers
even
don't
in-
bring cases, plaintiffs' lawyers don't bring cases unless there's some problem that's public. The issue here is trying to ferret out the wrongdoing before it becomes public.
But even with the randomness of SEC investigation and prosecution, there is a deterrent effect, because people, that's the one thing I think if you're in the boardroom, that you're really afraid of. You're not really afraid of Max because you can pay him off with insurance dollars.
Well, I think you're
Ferocious
afraid
as
of
he is,
reputational costs even
but-
more.
But
You're afraid of the New York Times
You're
even
afraid
more.
of it, exactly true. And no, if you get sued by Max, it's not going to get into the New York Times. If you get sued by the SEC, it does get into the New York Times. And things could happen to you that you could lose your reputation, you could lose your job, even if they don't charge you. It's much scarier. You know, that's what they think
Well, they could
about.
put you out of business.
They can put you out of business. They can put you out of a
I
job.
mean, the point that folks don't realize, there's not many cases where big companies ever fight government agencies. Never happens.
Right.
So, but let me continue. Isn't this an argument in favor of Jack's proposal then? So if you're saying the plaintiff attorneys can't do anything because they just don't have the tools the government does, let's give them the tools. Let's give them aiding and abetting. Let's get rid of insurance for the individual officers. Make the officers scared of the plaintiff attorneys. Would that address the concern about the plaintiff attorneys?
I like the idea about having the government agencies hire the plaintiff's attorneys better. That doesn't I mean, it's got its issues, but I mean, that's at least a system one could.
You'll end up with another set of problems.
It's a lot of tough problems.
Well, the issue will be how the plaintiff's lawyers were hired by the government
How
agency.
you manage
Yes.
them, it's, you know.
So other questions? So, yes.
I know that you folks discussed a little bit the European system. My understanding is that the European Commission is considering adopting sort of collective redress class action system in this summer, right, so in 2015, that would in some ways mimic the U.S. system. But one sort of interesting distinction that I identified is that associations would be able to bring a lawsuit, so private associations rather than actual shareholders, which might solve the circularity problem that Professor Coffey was mentioning. So pushing back a little bit on sort of the enthusiasm about the European system not having this system currently, but considering it even with the sort of the clarity of retrospect and knowing the problems that exist in the U.S. If you represent clients that do business with you or have those sort of concerns, is that something that's on your radar as defense attorneys? Have you sort of surveyed those possible changes, and do you think that they're an improvement over the U.S. system?
This is a long chapter in the book I keep citing to, but let me tell you,
Everyone buy this book.
to the extent Europe is considering anything, there are a number of European countries that have opt-in class actions. And whether or not an opt-in class action can be re-engineered so that it approaches the sweeping recoveries in an opt-out class action, there are possibilities. But beyond that, Europe also doesn't believe in contingent fees. They think they are immoral and irresponsible. That means you have to have a different kind of litigation funding. And there are third-party litigation funders, basically hedge funds, that do fund some European class litigation. London actually does have a securities class action. The third problem is all across Europe and all civil law countries, there's a loser pays rule. We don't have a loser pays rule yet, and till Delaware acts, I had to put a question mark around that, but all three of those have to be addressed to have an aggregate remedy. What you do about loser pays, what you do about funding if you can't have contingent fees, and how liberally can you make the opt-in class action approach, or at least roughly approach the opt-out class action.
The other thing that goes on in Europe, which is actually a good thing, which I've thought about, is that they have professional judges, and I often wonder whether the jury system makes sense in some cases like this that are very, very complicated. And one of the reasons people may not go to trial is because there's sort of a roulette aspect to it. And in the cases that I've tried, even in cases involving big companies, typically what happens is the defendants are looking for the smartest jurors and the plaintiffs are looking for the people that they think they can make an emotional appeal to. And that's big company, billion-dollar cases. And, sort of like who should win and who should lose sort of gets lost. And anyone who's ever sort of, watched a jury trial in a very complicated case has got to be asking themselves, can people really understand all of this and make sense of it? And it's potentially a problem. It's different in a criminal case where, even there, if you've ever listened to a jury instruction be given, you go, how are these people ever going to understand this? I can barely understand it, and I worked on it. But, that's, in Europe, they have literally professional career judges who decide a lot of issues, and that's a completely different issue than we have, because we have a constitutional right to have.
Yeah, I like the Seventh Amendment. I mean, I like securities juries trial, but I like the Seventh.
But you never try one. No one ever tries one.
I don't want to mess with the Seventh Amendment.
Other questions? All right, so we're almost at the end. Let me just ask one last broad question to tie everything together. So if we were to look to the future, and I sort of started with this question, what would you predict? Where are we going to go with class actions, with class cert? Any new developments or changes, or are we going to just stay with this ho-hum path we're on? What would you predict?
I mean, I think it's pretty clear that what you'll see is more muddling through. I think there'll be more securities class actions. They're not going away. They're not going to probably be more. They tend to be driven by stock market drops. So in the last year or so, the stock market's been going like this. The number of securities class actions has gone down. When the market goes down again, you'll see a lot more securities class actions. If the markets really keep going up, and you have a, if you have a regime change in the United States, you could have some, legislative fix that gets tried. But that's the only way that would ever happen.
Someone's going to try an arbitration clause, and the Supreme Court is going to uphold it, and it's going to blow the whole thing up.
That's good.
Yeah, I mean, the Halliburton didn't change a lot here at all. I mean, since 2008, you've been able to challenge price impacts. I don't think we'll see a huge difference. I think, as Bob said, with the volatility in the market, you'll see more traditional stock price cases. We don't want to give Max too many ideas here. A lot of cybersecurity, data security issues you'll probably see this year as that becomes a bigger issue.
Yeah, I agree with the other panel. I don't think Halliburton at the end of the day is going to be an inflection point when we look back at it 25 years from now. I think if class action, the course of class action litigation in the securities context is going to change, it's going to be something we don't expect, or it's something that hasn't happened yet, or isn't on the horizon, like, I don't know, maybe this arbitration idea.
I think the only thing that will destabilize the system significantly would be if some company following the new Delaware procedure adopts a bylaw imposing arbitration, and if the courts uphold that, that could end securities class actions. Other than that, I think continuity is much more likely than change. The one thing that is changing, the plaintiffs' bar is consolidating. Used to be a lot of boutique small plaintiffs' firms. They're now getting more and more consolidated around some large firms. The PSLRA really helped move that along, and practices like pay-to-play have also consolidated the plaintiffs' bar. So that's the major change that I see going on today.
All right, great. Any other questions? All right. I'd like to thank the panel. I've learned a lot today. Thank you very much.